Bob, you ready? You guys ready? All right, 6:30, and I'm going to call to order the April 3, 2024 meeting of the Hainesport Township Joint Land Use Board. We'll have a flag salute as the first order of business. Pledge allegiance to the flag,
To the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
My name is Tom McKay. I'm the vice chair. I'm sitting in tonight for Howard Crowpfeiffer, who was unable to make it for personal reasons tonight. So I'll be running the meeting in his place. May we have a reading of the Sunshine Law, please?
Notice of this meeting was published in accordance with the Open Public Meetings Act.
We have a standard announcement. There will be no new business started after 10 o'clock. I don't think that's going to be a problem tonight, given our agenda, but that is the standard rule we have. May I have a roll call, please?
Do you want, Mr. McKay, you have a letter file? Do you want to do that first?
I'll do that. I'll do that after. I'll do that shortly.
Okay. Mrs. Torti? Here. Mrs. Kelly?
Here.
Mayor Gilmore? Absent. Mr. Chakotay? Absent. Mrs. Baggio?
Here.
Mr. Murphy? Absent. Ms. Cosco?
Here.
Mr. Bradley?
Here.
Mr. Nogarita?
Here.
Mr. McLaughlin? Absent. Mr. Holden?
Here.
And Mr. Crowpfeiffer? Absent.
All right. Related to the roll call we just heard, I'm in receipt of a letter was passed on to me addressed to Chairman Crowpfeiffer, April 1, 2024, from Bruce McLaughlin, who was an alternate member of this board and previously a member. And Mr. Crowpfeiffer is advised by Mr. McLaughlin that McLaughlin tenders his resignation effective immediately for personal reasons. So we'll have a vacancy to fill, but that will be up to committee to take care of. All right, we've got two items for business tonight. The first is case 24-06 Ewing Auto Recycling LLC. Who's present for that? Would you please
Mr.
come?
Chairman, before you start that, I just have a brief statement to make so the board will know what's going on.
Absolutely.
This is an unusual application that the boards don't encounter very often. Maybe once a year or once every few years you'll get this. But the municipal land use law allows you to hear appeals where it is alleged that an administrative officer made an error in a ruling. So the statute specifically says that the board has the power to hear and decide appeals where it is alleged by the applicant that there is error in any order, requirement, decision, or refusal made by an administrative officer based on or made in the enforcement of the zoning ordinance. So that's what you have tonight. The burden of proof is on the applicant to prove that the administrative officer, who is Kathy, made an error in a zoning decision. And
that burden of proof is by what measure?
burden of proof is on the applicant.
By clear and convincing evidence or by mere preponderance of evidence?
I would say it's by a preponderance of the evidence.
Okay.
The statute doesn't say, but that's what it says.
Thank you, Mr. Kingsbury. I agree with what you just said. Good evening. My name is Douglas Harris. I am here for the applicant owner, Ewing Auto Recycling LLC. Ewing Auto is the owner of 10 Hainesport Mount Laurel Road in Hainesport, New Jersey. I expect that all of you have the packet and application that we submitted on behalf of the applicant, looking to discuss Ms. Newcomb's determination that, I have that right, I'm sorry, right, Ms. Newcomb? Yes, okay, right, Kathy, right, so I just want to make sure, okay, yeah. Determination that Ewing Auto's use of 10 Hainsport Road would no longer qualify for the grandfathered use of that property, which, as I understand it, had been grandfathered for many, many years, if not decades. With me tonight is Mr. Vega, the member of Ewing Auto, owner of the site. What appears to have happened here, and we, Mr. Vega and I, met previously with Mr. Kingsbury and Ms. Newcomb to discuss, is Ewing Auto is the owner but not user of that site. He's the landlord. He rents out this space to a third-party user. That third-party user, well, let me back up, I'm sorry. Let me give you a little bit of the history. The history of the site is that it has a grandfathered use. It's in an R1 zone, but as you saw in, I imagine, in my letter and in the resolutions that were provided and previously passed by this board, that R1 zone isn't an appropriate determination of that property or appropriate use, and so the use is as a auto dealership repair facility. And that may be a little vague, but we can get into that prior. Your board has determined and agrees with that in that the R1 zone is not really appropriate for R1, for a house. It's more appropriate for commercial use in this nature. Ewing Auto has no issues whatsoever with that and agrees with that. And what's happened here is that Ewing's tenant had a subtenant, and that subtenant went outside the parameters of that grandfathered use, meaning that the grandfathered use had a specific requirements that, while no longer exactly appropriate to the use, meaning that they were with the American Red Cross auto dealership that doesn't really exist anymore, but there was a use on that site. The subtenant went outside the parameters of that use. Ms. Newcomb noticed that, hey, that's not correct, that has to stop. Ewing Auto then had that stopped and moved forward. Ms. Newcomb, in her determination, said that use, and I think it was for 16 days, that 16 days of inappropriate or outside the parameters of the grandfathered use has rendered the entire grandfathered use of that site void, meaning that now it's strictly an R1 zone, and that any user of that site, whether it be Ewing Auto or a subsequent purchaser of that site or a subsequent user of that site, would have to go in front of this board and get an entire new use variance to allow for it to be anything other than the R1. Now, we don't think that's an appropriate determination by Ms. Newcomb, and would instead ask this board to make the determination that Ewing Auto and any of its subsequent users, meaning a tenant or a purchaser of that site, because Ewing Auto would like to actually, and is under contract to sell the site to a similar user, that similar user would not need to go in front of this board for the use that has been used on the site for decades, but instead would have to go in front of this board for uses other than that, if they want to expand, if they want to do other auto repair or auto dealership or anything outside of what's been done on that site for years and years and years. We agree. They would have to come back before this board and make that variance application and satisfy the township's requirements to do so. But if, as Ms. Newcomb contends, all of the grandfathered uses are gone because of this very small, inappropriate, or outside the bounds use, then that property is just an R1 zone. It's just a house. It's just appropriate for R1, and an applicant would have to go in front of this board not from an appropriate position, but from backwards, which basically would mean to our current buyer and to any subsequent buyer/user that you want to do auto dealership in a residential zone. That is a much higher hill to climb that would make the site, unusable now, and it would make the site pretty much unsellable at an appropriate price. So, just to wrap it up, your board previously had determined that R1 is inappropriate to this site, that the more appropriate use is the use that's on the site now, that has been on the site for years and years, which is what we want to continue. We are not here to ask for more use, different use, expanded use. That's not for tonight. That's for our buyer to decide if he wants to come before you and apply for it. And if he does, great. And if you want to approve that, great. More power to you. If you don't, that's your determination entirely. We're asking that we just take a step back and say that here's what's real, what we think is the right use of this site. It's continued for years and years. Let's continue it moving forward. Mr. Vega is here to answer any questions you may have. While Mr. Kingsbury correctly cites the municipal land use law, other than what's in the packet and any questions you may have, there's really nothing to determine. There's nothing to prove. I don't think I need to prove that the site was used previously as an auto dealership. I think we all know that. I don't think there's any dispute about that. And I don't think there's any dispute that the resolutions were passed by this board, or that what the board cited in the resolutions is accurate. Previous users have had dealer licenses that allowed for the dealership use for years and years and years. And any future user or buyer or continued use by Ewing Auto, if he so chooses, would be under the confines of those resolutions and builder licenses. I would welcome any questions or try to expand in any way.
Well, you're going to present any testimony besides what we've just heard today, which is not sworn testimony, but we can fix it.
Right. Of course, I am not testifying. I offer Mr. Vega to testify but I think it's more appropriate and a better use of this fourth time, and if you disagree, fine, to ask him any questions that you may have that would elicit further testimony. There's, I think the testimony is in the papers, but I offer Mr. Vega to respond to any questions.
Well, before we get to that, you gave us a lot of titles, owner, leaser,
Right.
et cetera. I want to get names because that'll clarify things.
Okay.
First of all, who's the titled owner now of the site?
Ewing Auto Recycling LLC?
And that's a
Yeah.
that's a corporation.
That's an LLC, yes.
All right. And are you testifying now on firsthand knowledge, or making these representations on firsthand knowledge?
I am not testifying. I am making representations based on my understanding as the attorney for Ewing Auto Recycling.
Okay. You are not a principal in any...
I'm not a
of the
member,
business-
I am not a principal, I have no business interest in Ewing Auto other than its attorney.
Okay. And there's a subtenant that was in possession of the property at the time
A
that...
portion of the property, the Ewing Auto had a tenant named Malone's Auto, who was a tenant user of that property. This winter, as we understand it, we were not involved in any subtenancy agreements with Malone Auto and its subtenant, but Malone's Auto, as I understand it, had some difficulties financially making the rent, and so they leased out a portion of the property to a subtenant. I don't know the subtenant's name, I don't know. But that subtenant probably didn't understand, or maybe wasn't even informed as to the restrictions on the property. Once we were informed that that subtenant went outside the confines, that's when we took action to end that use and to try and get back into the good graces of Ms. Newcomb. And that's where we are.
All right. So your gentleman in the audience is your only witness, I guess?
Yes.
So why don't we have him come up, be sworn in, we'll get information from him.
Sure.
Sir, raise your right hand, please. Do you swear or affirm testimony you are about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes,
Would you state your full name, sir?
Ricky Vega.
Mr. Vega, what is your position and association with Ewing Auto Recycling LLC?
I'm the owner.
Are you the sole owner?
Yes,
How long have you owned the business?
approximately 7, 8 years.
7 to 8 years,
Yep.
okay. Has the business operated out of the Hainesport Mount Laurel Road site that we're discussing?
No,
Has the business employed, or rather contracted with a tenant company to operate out of that Hainesport Mount Laurel Road site?
we simply rented the property out to another tenant.
All right,
Was that Malone?
Malone's Auto, yes.
okay. And how long have you rented or leased to Malone Auto?
It was 1 year, I'm not sure of the exact date. Do you have the exact date? It was 1 year ago, and then we just renewed the lease. It was actually renewed for 3 years total, the lease.
And that renewal was recently?
It was prior, September, I believe. I'm not sure exactly of the lease, how long it was.
All right, just as a little background, Malone's been in there for about a year, you told me a minute ago.
Correct.
So who was there before Malone operating the...
It was motor pool operation?
Is that the outfit that previously was known as Red Cross Automobile, or words to that effect?
It was known as motor pool,
Motor Pool?
yeah.
All right. Now, there was a subtenant that Malone had that was referenced. Who is that?
I believe they were Oxford Energy.
And what does Oxford Energy do as far as you know?
I believe they're AC company, AC and heating,
What does that mean?
air conditioning and heating.
Okay. Now, what do they do air conditioning and heating for?
For different companies, different buildings, contracts.
All right. They're not related to the auto sale or resale business?
Correct.
Okay. Were they occupying the whole site?
No.
This Oxford Engineering subtenant?
No.
What were they occupying?
The storage, they were parking in the back and operating in the back of the building.
When did you find out about the existence of the subtenant?
When Kathy advised me in an email.
Do you have any requirement with Malone in your lease with Malone that Malone could sublet the property?
I don't think we had anything against the subletting of the property. I don't think we put any literature in there.
So there was nothing in your lease with Malone one way or the other on subletting?
No, it was just a rental, basically.
Do you ever go by the property that you leased to Malone to see how things are going there?
I have plenty of other businesses, and I did not go by.
Is the subtenant still operating out of the business?
Correct, yes.
And
No,
is
the
it-
subtenant, no.
That's right, the
No, the
subtenant.
subtenant, no. The subtenant was out immediately.
All right.
Malone is still operating.
All right, I was going to say, is Malone still operating?
Malone is still operating, and the subtenant was banned from coming.
For the period that the subtenant was there, and how long was that?
I believe it was a couple of days. Miss Kathy had pictures, I don't know how long. I know for sure it wasn't more than 16,
16 days.
but,
I don't know.
Well, let's let the witness testify, counsel.
yeah, I believe it was no more than 16 days. I personally know of 3-4 days since I spoke to Kathy and I got them out of there.
All right. And is subtenant Oxford Engineering completely out of there now?
Yes,
Has Malone taken back or taken over that same space for its own use?
Malone never left.
Okay, well,
Sorry, what was that?
Malone
Malone has never left the property.
never left the property, you tell me,
Yeah.
but Malone allowed Oxford to use a portion of the property.
Portion of the property to help him cover the rental.
Was that, and my understanding from your prior testimony is that portion was some of the parking lot off to the side and out back of the building.
Correct.
And did Malone also allow Oxford to use portions of the building inside?
The back of the building. The building has back entrance and then it has garages in the front. So Malone was still operating out of the complete front of the building.
And there's some back room or backside space that Malone allowed Oxford to use?
Yes.
And is Oxford out of that completely, that
They're
space?
completely out of the space, inside, outside, everywhere.
All right, and now Malone has control over the whole space,
Correct.
and does Malone continue to do its auto sales
Correct.
business out of that space?
Correct.
All right. Did Malone ever consider going to see Ms. Newcomb before allowing Oxford to sublet a portion of the property?
I cannot speak on his behalf if he did that or not.
What instructions, if any, did you, as the principal of Ewing Auto, give to Malone?
To go down to the township and speak to Miss Kathy?
Well, that's right, yeah. Did you?
That's what I instructed him to do.
And was that in connection with his communication to you that he wanted to sublet part of the property?
It was in connection, and he was trying to get the sublet to stay in there, and when Miss Kathy said no, I told him, listen, I don't need my licenses revoked, he needs to go.
All right, so let me just understand the sequence. Did Malone bring the subtenant in before you had the conversation with Malone about going to see Ms. Newcomb?
No, Malone, yes, Malone brought the tenant in himself. I didn't find out about it until Kathy sent me an email.
All right, and then you instructed Malone, you better go down and talk to Kathy Newcomb?
He explained to me that he wanted the subtenant to stay in there because he was helping him cover the rent, he was struggling paying the rent, and he wanted the subtenant to stay in there. I said, if that's the case, go down and speak to Kathy. When
All
I
right.
spoke to Kathy, Kathy said, absolutely not.
Have we pretty much covered the extent of your knowledge of this situation?
Yes,
Anything else you want to add?
not at all.
Did I miss a question do you think I should have asked you that would develop the facts to help you?
No, I mean, not at all. She asked me to have him remove him from the site, and I did.
Mr. Vega, if you had a third-party purchaser or new tenant after Malone's tenancy expires, would you require that new user to meet with the town to discuss use of the site and what is and is not permitted currently, and what to do to extend or expand upon the use.
Of course, yes.
All right. Counsel, you have any other
No.
evidence to present?
I do not.
Ms. Newcomb, can I ask you to give us the facts as you know them from your point of view?
Sure. I'll step up.
Yes.
Kathy, I'm going to swear you in. You swear or affirm the testimony you give tonight to be the truth, whole truth, nothing but truth, so help you God.
I do. Good evening, folks. Kathy Newcomb, Hainsport Township Zoning Officer. So, before you in the packet, I put together what I felt was a fairly strong packet on my decision of why I felt that this pre-existing non-conforming use, which had been approved back in the 80s and then went through other tenants or other buyers as well, that also had to come to the board. And I felt that this was an abandonment use. Mr. Vega's attorney has exactly what you have in front of you. I emailed that to him, and his reply was thank you, and I felt that, that was the right thing to do on their behalf, to see what I was presenting you folks. So if you take a look at the cover page that I've given you, I briefly outline the documentation behind it. This particular property has extreme history in it on many different levels. The Exhibit 1 that I gave you was the tax document showing the owners of that property, which was Ewing, or is Ewing Auto Recycling LLC. Exhibit 2 are the pictures with the date that I found this on January 4th of 2024. That is the HVAC company in full force with the bins, all the materials all over the ground. You can take a look. Several pages down, over I should say, you will see the Oxford Energy truck behind the fencing. It was all of their employees there, and using the site to the fullest extent.
Kathy, how many photos in total do you have there?
Well, they're double-sided, so 1, 2, 3, 4, 5, 6. There's about 10 or 11 here. And again, they're double-sided.
Okay, 10 or 11 photos. Let me just, want to get these marked, because I think we should have a marked record of exhibits.
Okay.
So let me take, would you call it one packet that you have?
Correct. What I had done was that I had put this piece together in all of your packets,
Okay.
as well as to Mr. Vega's attorney.
So we'll call your packet, as you refer to it, as Exhibit 1.
Okay,
And Exhibit 1A will be the tax documents.
okay,
And Exhibit 1B will be the 10 or 11 photos.
okay.
And so we'll go on with the other documents and label them C, D, E, F as
Okay.
you identify them.
May I continue?
Yes, I'm sorry. Go ahead.
So one of the most important documents that I felt was the fact in Exhibit 3 were emails of the initial day that I sent to Oxford Energy. It's dated January 3rd. It was sent.
All right, well, we'll call these emails collectively Exhibit 1C. And it's a January 3rd email?
Correct.
And who's it from and to?
It is to Oxford Energy directly, okay?
Okay, from you.
You'll see it says, "Good morning, Joe. This email comes to you in regards to storing your Oxford Energy trucks at the old auto dealership. You are not permitted to be there. Please remove all trucks and any use of the building by Monday, January 8th, or court proceedings will start. So if you move forward on that, is that at the top of that, it says, is the dumpsters being removed today along with the material on the ground? That was to Mr., I'll say Oxford Energy again. The next page, you will see below at the bottom of the page, and Mr. Vega is CC'd on it. It states, "Good morning, Kathy. Per our conversation last Thursday, we removed everything that belongs to us from the site. The dumpsters belong to Ricky."
Ricky being Mr. Vega.
Correct. Thank you, Joe. And when you read above that, it says, "I guess he was allowing them to be used by Oxford then for the material. Ricky, when will they be removed as they are not permitted there?" I feel that one of the most important statements is the one that I'm about to read you.
All right, give me, what are we reading from, another email?
Yes, this is the second page in that document, Exhibit 3.
And what's the date of that email?
January 8th, 2024,
And who's it to and from?
Mr. Vega.
From you?
Correct.
Okay.
So Mr. Vega emails me back and states, "One or both will be out today depending on how busy my drivers are. And Jerry said he will go back there and be using the property until I find another tenant. As this really has messed me up financially, this building has been nothing but a headache with the town not allowing anyone to do much, making it really had for business, I'm assuming the word is hard, but for business people to operate and make money." I knew for a fact that Mr. Malone was no longer there, because he did come to see me as well. With that being said, you'll see the history behind all these documents. Their approval for their zoning application when Mr. Vega bought the property. And I'm reading in regards to each particular piece of paper behind that. The Hainesport zoning permit was on 9/8 of '22. And it specifically states resale of used auto only, services minor only for cars for resale at site, no body work, no outside repairs permitted, no towing, no junk cars, no storage or junk cars, or inoperable cars on the site for the business. See paperwork in the file. And then behind that is the handwritten application that was submitted to me along with the fee. So as you go through these documents, you will see is that Mr. Vega and Mr. Malone both signed a document on 7/26 of '22 that states that they understood all the requirements of the resolutions on this property.
All right, we'll mark that as Exhibit D.
So with that, behind those start the resolutions of 1999, when Motor Pools bought that.
All right, well, so we'll categorize the resolution history that you have in your packet.
I don't need to go through that, it's self-explanatory.
Right, that's Exhibit 1E. So we have Exhibits 1A, B, C, and D.
So where my determination came in, Mr. McKay, was the fact is that I felt that there was enough evidence to show an abandonment issue. I was on vacation for 11 days during the week of Christmas time, and they had been in full operation at that point. Approximately 16 days is what the attorney stated.
The Oxford Engineering Company.
Correct.
Okay.
Yeah, they're an HVAC company.
Kathy, was Malone, during the period that Oxford Engineering was in there for the 16 days or so, was Malone operating, or did it appear that Malone was
No.
operating any car sales
None.
on the property? And what became of all the cars that we typically have seen at that site?
I can't speak on his behalf where they went.
They disappeared?
Yes.
So we had a building at the point in time of your inspection of it, visual inspection of it, that that it appears to have been solely occupied by Oxford Engineering and all of their materials and trucks.
Correct.
All right, what's the status of the property today?
So at this time, they chose to put 3 cars on the front of this property. I made a decision not to take that to court yet because they were told that they were no longer allowed to be there. So.
Malone was told they were no longer allowed
And
to be
Mr.
there.
Vega, correct.
Okay.
And the fact is that we did meet with Mr. Vega's attorney, Bob, Mr. Kingsbury, and myself. And that meeting ended abruptly because there were statements made that once you start to say certain things, is that no longer will I have a conversation with you. And when I say that, it talks about the fact is that if you're going to make attempts to intimidate and want to sue the town because we're not allowing you to do what you want, that conversation ended, and I have that time and date that I ended that conversation. Mr. Kingsbury was there as well as Mr. Vega and his attorney. At this point, I explained to Mr. Harris that I would no longer talk to Mr. Vega. I would only talk to him as his attorney. And at that point, which obviously he decided that he'd like to appeal the decision, which we know they have the right to, he got the application from Ms. Tiver to move forward with the appeal.
All right.
Mr. Harris, do you want to ask the witness any questions?
Well, first of all, I just want to say that I don't disagree with anything Ms. Newcomb
This is
testified to.
not time for a speech. Only time to ask Mrs. Newcomb any questions that you want to ask to support your position.
All right. Ms. Newcomb, at any time did you, after your discovery of Oxford Energy's property on location, did you communicate with Mr. Vega and have him disagree with what you asked for? Let me say it a different way, I'm sorry. Did he say, no, I won't do that?
No, he didn't say he would do it. He understood that they had to leave.
Okay, so,
Because it said that
when you asked him and said that there is an inappropriate use on the site, it has to stop and has to be remediated and addressed, he then did that.
Correct.
He then addressed it.
But he also had explained to me that he was not aware that they were there. But in his own emails, he states that those are his bins, that he will have them removed.
Right.
So he had knowledge that they were there because he gave him the bins. So how did he not know that until...
Let's not cut the witness off. Please finish your answer.
So the fact is that what I find contradictory in this is that his testimony was that he did not know about this until I called him and let him know and emailed, when in fact, in his own email, he states that he will have to have Mr. Malone come back and that those bins will be removed by his drivers and that the dumpsters were his, according to Mr. Malarkey.
Weren't the bins there previously?
No, sir, they're not permitted there.
But weren't they there already?
No, they were not.
Okay. This is where you want
All right, well, let's have an orderly progression.
Okay,
If you have any other,
another question.
if you have any other questions,
If the bins were there previously, would that mean that you had seen those bins? Or that they were allowed to be on the property?
No, they're not
No.
permitted. We don't allow those bins without site plan approval to be on
What
these
would it
properties.
mean if those bins had been there for years?
Sir, they were not there.
you have no further questions. All right, thank you, Ms.
Thank you.
Okay. Mr. Vega?
All right, Mr. Vega, you were going to call Mr. Vega to testify? Mr. Vega, you're still under oath. Take the stand, please.
Can you talk to the history of the bins?
The bins were there because Jerry asked me to put them there so that he can throw some metal away.
Jerry is Jerry who?
Malone's auto.
Jerry, the
Yeah.
owner of Malone's.
Yes.
When did Mr. Malone ask you to put those bins in?
He asked me to put them there probably a month prior to that.
Okay.
And he said he needed them because he needed to throw some parts in there and get rid of them. I just never had time to come back and grab them, and I didn't even know that they weren't allowed.
Okay. So did anyone at any point say to you that the bins needed to be removed?
No, not until I received an email from Kathy saying these bins need to be removed.
And once you received that email from Ms. Newcomb to remove the bins, what'd you do?
They were removed.
Okay.
Instantly.
So let me just make sure I understand the timing of the bins. They were there when?
They were there for around a month, complete.
Beginning when?
I'm not sure exact dates, but let's say it's
December?
whenever Kathy sent the email, a month prior to the
Okay. And after you were told that the bins needed to be removed, how long were they there?
Approximately 3 days, 3-4 days. She gave us 3-4 days to remove them, and they were removed the day of.
In any way, did you just do anything contrary to any of the requests of Ms. Newcomb?
No.
Let's talk about, I just want to clear up for this board as best we can. Ms. Newcomb mentioned our meeting and the abrupt and, I was there, I don't, after Ms. Newcomb left the meeting,
Yes.
did it end or did we continue to discuss with?
It continued,
Ms. Ginsburg?
it continued between me, Mr. Harris, and their attorney.
Okay. You didn't say anything to Ms. Newcomb that was insulting or impolite or anything other than outside the confines of our dispute, right?
Mr. Harris, we're not going to consider that anything that occurred during that meeting. We're interested only in the facts of the site, so.
I understand, and I appreciate that. I just want to make sure the board understands that there wasn't like a fight or that there was no like insults or anything.
The board understands that, and are not holding that meeting against anybody at all. It's not going to be a factor in this decision. The board will deal with the facts on the site.
Okay, one more, thank you, sir. One more question. If the site is, if the use of the site is abandoned, what can be done if it's an R1 zone? Does it have any value to you whatsoever?
It has no value, and I purchased the site probably only a year ago.
Would you be able to conduct any business on the site?
No,
Would you be able to sell it to any user other than someone who intends to use it as an R1?
no,
Is there a house on the site now?
no.
What's on the site now?
8-bay garages.
Would you be able to rent it to an appropriate user, who would use it in the way that it's been used for decades?
No, and it would devalue my property big time.
Would you have to knock down the building that's there now in order to put a house on it to use it as an R1 zone?
To turn it into R1, yes.
What else would have to be done to the site to put a house there so it would be used as an R1 zone?
Demolish it and rebuild. There's
So
nothing
you
else.
have to tear down the site entirely and build a house
Yes,
for it to have any value if the use is abandoned
yes,
because of the subtenant's actions.
yes, correct.
Okay. Thank you, Mr. Baker.
All right, Mr. Vega, just a couple of questions. A board member would like to know if Mr. Malone or the Malone Auto Company is still in control of the site under their lease with you.
Yes, he is, but he is willing to leave the lease if I sell the property, because he is having trouble paying the rent.
So Malone's activity on the site after the Oxford Engineering Company took possession of the building was, or has been limited to clearing out the 2 dumpsters, is that correct? And putting 3 cars on the property?
He has vehicles on the property for sale, and one person sitting inside running the place. That's it.
And did that continue, did that operation, one person or a person and a few vehicles, Did that continue during Oxford's occupancy of the building?
Yes,
And does it continue today?
yes,
When you bought this building, I think you said about a year ago,
yes,
you bought it with the rights to sell autos out of that building, subject to the previous board approvals.
correct,
And you understood that, correct?
correct.
So you bought it with eyes open with that limitation?
Yes, with selling vehicles, yes.
Okay. And did Ms. Newcomb ask you to come back before this board for any approvals in connection with your purchase?
No,
All right, you understood that you were buying this property subject to the prior approvals, and that you and whoever worked for you or was your tenant had to follow the same rules, correct?
correct,
And as far as you know, Malone was following those rules up to a point, correct?
correct,
And as far as you know, Malone then violated its understandings with you by allowing Oxford Engineering in to use a portion of the building.
correct. Yeah,
All right, any other board members have any other questions?
I did purchase it in 2022. I believe she stated the exact date when I purchased it.
Well, maybe we can just get Kathy Newcomb, can we get maybe it's just a stipulation as to the date?
Well,
If not, we can't,
in
then,
the tax program, it states sale date of 6/30/22. And you all have that in your packet.
right. So does that date
correct.
jive with your recollection?
Correct.
Okay. Any questions the board members have of the witness? Mr. Harris, I don't want to leave you without...
One, Mr. McKay?
Yeah.
How do you know that Malone operated continually during Oxford's tenancy?
That's what he spoke on, and that's what he told me.
All right, so you're only relaying what Ms. Malone, is Mr. Malone here this evening?
No, he's not. I personally went down to the property afterwards when she sent me an email because I came down here to speak to her instantly.
Right, but you didn't know that Oxford was operating there, so how would you know that?
That's when she sent me the message, I went down there today to do the property. And
So
Malone,
you're operating based on Mr. Malone's?
no, I physically seen him in there myself, him and.
Right, but
him and-
after Oxford had already been in.
Yes, him and vehicles were inside of the
He could have
property.
moved back in at that.
I mean, she sent the email and I was there within half hour. So he moved in 30 minutes, yes.
Okay.
So there was no conversations, he was struggling to
Yes,
pay rent.
yes.
I mean, with him and yourself and Malone, was there any, did you talk to him about what he's gonna do, or how could he?
I did
make
talk to him
rent?
about what he's gonna do, and then we spoke about, well, maybe I put the property back up for sale. I don't wanna go in there. I own two other junkyards, about 40 other properties that I rent. I don't have the time to come personally and run every one of my businesses. So we spoke about it. I said, I'll put the property up for sale, and we can find another tenant or sell the place. And then that's the last we spoke.
So are we to understand that Mr. Malone is physically there but not paying rent?
Right now, yes. I haven't received rent in 6 months.
Okay.
And the reason that he gives me that he cannot pay rent is he tried to put 50, 60 cars on the property, and Kathy said it's not allowed, and if he doesn't have the inventory, not enough flow coming in and out of there to pay the rent.
How many cars could be on the lot?
I believe she told him 20.
20?
Correct. There was, during the course of the years of approvals, the previous owner also had to come back several times in order to change some things. But again, as Mr. McKay had asked Mr. Vega, was that, did he understand the resolutions? And those resolutions specifically outlined everything. Mr. Harris was part of when Mr. Vega bought that. I have emails from Eileen Fahey, who was the seller's attorney, along with Mr. Harris?
The day that the old tenant moved out, he had over 150 vehicles on the property, and he's had it there for over 5, 6, 10 years.
Talking about the person that you bought.
From Motorpool, the person I brought the company from had over 150 cars on the property, and we have pictures of that.
Hard to believe you could put
There's a
150
property
cars
that big.
on that property.
I'll tell you.
I can show you pictures of that.
At once, there were times when you drive, when you cross over the tracks, that place was exploding with cars.
Yes.
I didn't realize there's room in the back, and maybe that's where the other cars were, but man, that place was jammed. I mean,
Yes.
there were all kind of cars over there.
And then we were instantly asked to remove a tow truck from the property that I purchased from the owner.
But it's not your intention to have 150 cars on the site?
No, but
Okay.
100 vehicles on the property makes it a lot easier when a customer comes into the property, into a showroom, and walks around, and it's easier to sell a vehicle when you have 100 vehicles versus 20.
I expect, not being in the business, but I expect that sounds
Yeah,
right,
So it
but it
made
does
it-
violate,
it made it difficult.
it does violate the approvals.
But that's in violation of the rules, and that's not your intention or
Yes.
and
My assumption in the beginning was I believed that that was allowed there.
but if a third party intends on buying or renting from you in the event that Mr. Malone is out, and his or her intention would be to have 150 cars on site.
And I'm going to
or
advise you to
anything,
come here to the board and ask for the permission to grant that.
You would make it clear to him.
Yes.
Would you not, that that's not allowed, and to do that would require application to this board for permission to do so?
Yes.
All right,
And
so-
I did make it, in the first meeting that we ever had, I did make it clear to Ms. Kathy that we were intending to put a bunch of vehicles on this property. She made no hesitation to say no about that. She actually told me that she wanted to speak to a person across the street to see if we can have more rental space from him and to have him sign it. And that's in her emails.
That's because Motor Pools had an agreement with Prairie Videx. I took Motor Pools to this board, and it is on record, being questioned of what he was allowed to do over there. I don't know if any of you remember that or not, but I put Motor Pools in violation. The attorney was Pat McAndrew, came to the board, and the board made a decision of what they were allowing to happen over at Prairie Videx. That wasn't my choice. I did my job and put them in violation. The issue here is that I feel like we're not discussing the abandonment issue as much as we are whether or not that you could have 150 cars and you don't want to follow a resolution, or the fact is with our EDAC meetings that we had with Mr. Vega, there was nothing said in regards to how many cars he could or couldn't have. It's extensive. You don't even have half of the information of the history on this property, because I didn't feel that it was substantial for my decision of the abandonment of the use of the used car dealership as compared to what was on site with the Oxford Energy. And the pictures show it was in full use. And then again, the email states, Mr. Vega says, he will have to go back over there. Well, if he didn't leave, why would he have to go back over?
All right, anything else, Mr. Harris?
I have a question. Did you have a written lease with Malone?
Yes.
Does it say anything about whether subleasing was permitted or not permitted?
No, we didn't have any literature on there.
Yeah, I think you told us before that your
Yeah.
lease with Malone didn't cover subleasing one way or the other.
Yeah,
Correct.
I'm sorry, let me just interject. It's a all-state form lease. It may have sent a sub-letter or assignment language, but there was no, as I and Ms. Vega will testify, there was no discussion as to whether or not subleasing would be approved or not approved or something. I just don't want this board to think that this lease doesn't have language that we're not aware of.
Well, we don't have the lease, we only have the witness's best recollection. So on the sublet agreement, with Oxford, was that reduced to writing even if it was just a form lease?
No.
So this was-
I have no lease as well.
So your deal with Oxford was a handshake, you can use,
I don't have a deal with Oxford,
or rather Malone's deal with Oxford was a handshake, as far as you know.
I would assume.
You don't know,
I don't.
one way or the other?
I-
I mean, you never asked
No.
Malone?
I asked him what he did, and he said he was gonna pay me money to help me cover the rent, because I'm struggling since I cannot have vehicles on the property.
If this board concludes, and I don't know what they're going to decide, but if this board concludes that there was an abandonment, what will you do?
I don't know.
What will you do with the property?
I have no clue.
You-
If you conclude that it was abandoned, I have no clue. If it doesn't, supposedly I have a closing at the end of the month, depending on what this board decides. And I will be closed and out of that property with the same use. And if they have any issues with, they would have to come above the board, and I would make it clear with them that they have to come above the board if they want to add more vehicles. These are the troubles that I had on this town with parking vehicles there.
So you right now have a contract buyer for that property
On April 30th, yes.
on April 30th, and that buyer,
Contingent that the use remains the use that it's been for decades.
that's part of the contract, that
That's
the
the
buyer
contingency, yes.
can continue to operate a motor vehicle sales operation subject to the existing
Use,
township use requirements.
correct.
All right, thank you.
Thank you.
Mr. Kingsbury, subject to your guidance, I guess the board has a decision to make.
Well, I have some comments.
No.
As Kathy Newcomb stated, this is an abandonment case. Abandonment is not a bright line in the law as to when an abandonment occurs. Probably the most famous abandonment case in New Jersey history is Saddle River versus Bobinski, which is a North Jersey case in which the property owner had a horse stable that had not been used for 28 years. Did that constitute an abandonment? The court found that it did not, because he had kept the stable in usable condition, ready to reinstitute the stabling of horses. So there's a time element involved. How much time has to pass for there being an abandonment? And what is the intent of the owner of the property is the other factor you have to consider. Did the property owner intend to abandon the use of the sale of used cars by the presence of Oxford? And was there sufficient amount of time that you think that constituted an abandonment? It's not an answer I can give you, that's what the board purpose is tonight, to make their own determination. But you have to consider intent of the owner and the time period involved as the two major factors in an abandonment.
Mr. Kingsbury, a board member inquires as to whether we're going to have public participation on this issue. I think,
It's basically a legal question to be decided by the board.
and if you had to pose the question to the board that would have to be answered by the board, yes or no, it would be whether there has been an abandonment of the property or not. Subject, and the determination of that is based upon the two criteria that you just set forth in the case.
If I were phrasing the question, I would put it this way. Did the presence of Oxford constitute the property owner's intent to abandon the sale of used car use? by what we call an intervening use. That wipe away the past and not allow them to resume the used car business without coming before the board for a variance.
Okay. Do all the board members understand the question posed?
I have a question for our attorney.
Okay.
Mr. Kingsbury, would there be a time element in that question, over the use?
There is a time element, yeah, there is a time element.
Did Mr. Vega actually abandon the property?
That's a question you have to, the board has to answer.
That's your decision.
Despite the fact that he has a tenant who is not paying rent,
He
he's
abandoned
ultimately...
his right to use the property for the used car business.
Okay. Despite what the tenant or the subtenant did, he's ultimately responsible as the owner of the property.
Well, that's for you to decide whether he knowingly did it or not.
Okay. Thank you.
If he knowingly, if he knew what was going on there, that's a factor you need to consider.
All right, so the question's been posed to the board. Can we have a roll call?
What's the question? What are we voting on exactly?
Mr. Kingsbury, could you just restate the question that has been
Sure.
posed to the board so that the whole board can hear it again?
This property was approved previously by board action for the sale of used vehicles. The question is, did the owner of the property abandon that use by the presence of an intervening business, namely Oxford? Did the presence of Oxford for the 16-day period, and I'm assuming the 16 days is accurate, did that constitute an intervening use which indicated an intent to abandon the previously approved use of sale of used cars?
Okay, and I'm sorry I have to ask you this, but Kate, just make sure the board members understand, what are the two criteria that you previously talked about?
The two criteria are, what was the intent of the owner of the property? Was it his intention to abandon the previously approved use? And was there a sufficient time period to indicate that the previous use was abandoned in favor of a new use?
Mr. Kingsbury, I would ask that...
He's entitled to make his argument.
I would ask that the board consideration also include the understanding that Mr. Vega, upon notice from Ms. Newcomb as to the improper use, sought to and immediately did address that improper use.
All right, Mr. Harris, what I'm going to do is this, to be fair to you, I wanted to make sure the board understood the question, and I wanted to make sure that the board understood the criteria that council has relayed out to us. I'm happy, if you want, to give you 2 or 3 minutes to sort of sum up and argue your position.
Okay, I don't even think I'll need 2 or 3 minutes, but thank you. I think Mr. Kingsbury's framing of the question is correct, but I would ask that this board also take into consideration Mr. Vega's actions upon learning of the use that was outside of the intended use, the approved use. So when Mr. Kingsbury's question is, did Vega or Ewing Auto abandon the grandfathered rights, this board should absolutely take into account Mr. Vega's actions when he was informed of those rights. If Mr. Vega ignored or disagreed, or this use had gone on for weeks or months, or as Mr. Kingsbury discussed with the board firm, for years, that's a consideration. The other consideration would be that what did he do when he heard of it? And I think it's clear from the testimony that when he was informed, he addressed. Did he address instantaneously, or did it take a few days, or did it take
5 days, he was informed and addressed. Clearly, that action on Mr. Vega's part should be a factor in your decision as to whether or not his actions, he intended to abandon that use. Thank you.
All right. Mr. Kingsbury, just in terms of the mechanics of this, what if a motion is made, one way or the other at this point, and then the board can either vote the motion up or down? The motion hypothetically would be a motion to determine the use not abandoned.
You could make a motion to either affirm Ms. Newcomb's determination, or you could make a motion to determine that there was no abandonment.
Okay.
Mr. McKay?
Yes.
Can I have my 2 minutes as well?
Well, Mr. Newcomb, I would never deny you the right to contribute to this board, which is, its contributions are always welcomed.
So, again, I'd like to reiterate the fact that in this email of January 8th from Mr. Vega himself, where he talks about the fact is that he will get those dumpsters out of there, that Mr. Malone will have to go back over there and be using the property until I find another tenant. As you had asked me, was all the material of Mr. Malone's gone? Yes, all those cars were gone. The fact is that in this written email from Oxford Energy, he states that the dumpsters do belong to Ricky Vega. The fact is that if Mr. Malone was always there, why would he have to go back over there? Is a key element in his own writing in this email. And the fact is that Mr. Malone could no longer afford the dollar amount that he was charging him every month, that he had to get a subtenant. My question as well is that, would this still be going on if I didn't address it? Was Mr. Vega going to get rid of it on his own? Or would he be collecting money to pay the rent that Mr. Malone could not from Oxford Energy? So if I, as a zoning officer, did not do my job, and I drove by this every day and just ignored it, would this still be there because he would be collecting rent and getting his money? So I feel that I made my decision on several different issues, and the intent is that as long as I'm getting money from somebody, and they can stay there, then I'm going to let them. Unless the zoning officer, who apparently has been giving him a hard time through his whole entire ownership of this.
Excuse me, I don't mean to interrupt, but I don't think that's appropriate for this board.
Well, I do, sir.
Whether or not what...
Mr. Harris, the statement has been made, your objection has been noted by the board. Thank you.
I'm concluded. Thank you.
All right, so may I have a motion from a member of the board, one way or the other on this? Well, hearing none, I'll make a motion. The motion is to affirm the decision of the zoning board officer.
I'll second that.
Okay, roll call.
Mr. McKay?
Yes.
Mr. Bradley?
Yes.
Mrs. Twardy?
Yes.
Mrs. Kelly?
Yes.
Mrs. Baggio?
Yes.
Ms. Cosco?
Based on the two criteria that need to be met, I don't believe that what was presented today establishes a strong case that the owner of the facility made an intentional intent to abandon the property. I do think that the leasee was primarily responsible for this, and I don't believe that there was sufficient time period. I do believe that we have the best zoning officer here. I do not believe that she is inappropriate in her decision, but I don't want to get into a he said, she said here. I think that I need to show deference to the owner. He's established that he's going to be trying to sell the property. The value of this property will be affected negatively, so my vote is no.
Mr. Nuvarita?
My vote is no also, because he has a possibility of selling this at the end of the month, and with everything that's on the table, the person that's buying it hopefully follows what needs to be done, so that's why I'm voting no.
Mr. Holden?
I vote no also.
Yep, that's everyone.
Can we change a vote? Is it too late? Because I'm listening, and I think that although the owner was responsible, I agree, I don't think his intent was there. I don't think the intent was there. And I struggled with that in my mind. Even though you were responsible, your intent was not there. So I am going to change my vote to no.
And I am also going to, as you saw, I took a long time to reply because I was struggling. And for the well-put words of Paula, no disrespect to our zoning officer. I don't think the intent was there, nor the time.
And none is taken.
All right, so we're clear. If anyone wants to change their vote, they should speak up now.
Can we do a new roll call?
No, we don't need another roll call. Roll call's been completed, correct?
Yes.
What's the count on the vote now?
It's 5,
5 for or 5 against?
5, 4, while 5 that the intent wasn't there.
Was not there,
Correct.
so the motion fails. Correct?
That's correct.
Okay, then the matter's closed. The motion fails. And,
I'm sorry, well, I appreciate that. I just would ask for some clarification. Does that mean that
Mr. Kingsbury, I don't want to,
yeah, I don't want to speak for this board, or
My recommendation would be that you have a motion and a vote to reverse the decision of the zoning officer and see how that comes out.
okay, so we've had a motion to affirm, to affirm the decision. That motion fails, 5 to 3?
3.
5 to 3. So the present motion that I'll make is to, what did you say? We really want to
Reverse the decision.
reverse the decision of the zoning board officer and allow the use to continue, subject to all outstanding requirements.
I agree.
Okay, so that is the motion that is now on the floor. A yes vote means you're in favor of reversing and letting him continue to use, subject to all the outstanding requirements. A no vote means you're not in favor of that. So we have a roll call.
Can I have a second on that?
I'm not sure I understand that. And I'm sure there's some of the other people here that don't quite understand that as well.
So it means
What are we voting on? We're going to reverse the decision that was made
By the
Zoning
zoning officer.
officer.
that said that her appeal, or the appeal,
They won their.
they won the appeal. We don't want to reverse that, do we? They won the appeal.
No.
Council has suggested,
You haven't decided that yet. I thought we voted 5 to 3.
Yeah.
We want to reverse
I thought it
the
was 4 to
decision that the
4.
property
No,
was
it's-
abandoned.
Oh, it was 5-3.
5-3.
Oh, okay, I thought it was a tie vote.
No.
I don't know that we need a new vote. I would just ask for Mr. Kingsbury to clarify that what that vote means, so that I
I don't
can
think it means
probably-
anything.
Good to go.
Yeah, that's
On
what
to
it is.
you.
Business as usual.
Was it a?
They're all good.
No,
No.
it's 5 noes and 3 yes.
Yeah. It was a negative. We don't need another vote. We're good.
No.
We don't ask for a vote. I think the board has been clear. I think the 5-3 vote is clear to the best we could. I would just ask, I want to make sure that I understand that means that the use as it had been continued.
Yeah, I agree with that. I thought it was a tie.
No.
All right, that's why.
We done there? Yes.
The vote was taken, and then there were 2 changed votes.
Yes.
So,
Right. Okay. So, Mr. Kingsbury, would we need further clarification on, I would need that.
The motion was to
Affirm.
affirm the decision, and the vote was a negative on that.
Yes.
Right.
right,
Right,
I
okay.
vote.
I think that's it then.
good.
Okay.
Done.
Another vote.
Fantastic. We don't need another vote. Thank you very much.
He's going him to sell it and see if he can get somebody that's gonna.
Good luck.
All right, case administrative amendment. Mr. Kingsbury or Ms. Newcomb? Mr. Kingsbury or Ms. Newcomb, you want to give the board some background on this item?
Hi, it's the Kathy Newcomb Show again.
Oh.
Good evening, folks.
Always good to see you, Ms. Newcomb.
Long time no speak.
Yes.
So the next application is in regards to Black Creek, into a fencing that we're looking to do around the perimeter of the existing houses that back up to this property. So with that, many of you have, I believe, the layout in front of you where that's going. We do have somebody here from Archer and Griner, am I correct, Mr. Ponte? Please come on up and we'll have Mr. Ponte swear you in.
All right, can you give us your full name?
Attorney.
He is the attorney.
Give us your full name, the firm you're with, who you represent.
Good evening. For the record, my name is Alec Fonte. I'm an attorney at Archer and Griner, and I'm here on behalf of the applicant, BTC3, Hainsport LC Urban Renewal LLC.
What are you seeking?
This evening, we are seeking administrative approval to allow for the installation of a 6-foot-high privacy fence along the western boundary of the property, which abuts residential uses along Main Avenue and Ingleside Avenue. The applicant has requested administrative approval to install the privacy fence and will coordinate with the board planner on revisions to the previously approved landscaping plan in order to help screen the previously approved sound wall. The applicant also plans to connect the fence to the sound wall. It is important to note that the applicant is making these revisions on the specific request of the adjoining property owners who want the fence installed in order to help protect their properties from trespassers who tend to walk along the Conrail rail lines on the northern part of the property. As a result, the neighbors also requested that we connect the fence to the northern boundary of the sound wall. Joe Fierro, a representative of the applicant, has spoken with the neighbors who are all fully in full support of these proposed revisions. Joe Fierro also had each of the neighbors sign statements of ownership, consent, and support for the project. These consents were shared with Paula Costco. If we have extra copies, if the board would like to see those. Additionally, in connection with this request, the applicant has prepared copies of the proposed fence sketch plan. So if the board would like to see those as well, we have copies.
The consent that you've obtained from the neighbors, how did you determine which neighbors you would include in the consent arrangement?
It's 4 different properties that are all abutting the proposed fence.
All right. Do you have an approximate distance from the fence or the proposed fence where these neighbors are situated?
Not a specific number of feet, but it's all under 50 feet if I had to guess.
All right, and these are all on Ingleside Avenue,
Ingleside and Main Avenue.
both Ingleside and Main, okay.
Chairman, do you mean the offset of the fence from those property lines or the length of that fence?
If you look at the plans for the sound wall,
Right, I was just trying to ask, you were asking about the distance. I believe that the fence line is to run at the property line with those adjacent residences. The sound wall is actually set about 20 feet or so into the Black Creek site. So this fence, this will be a 6-foot high vinyl fence on the property line. The sound fence will be about 20 feet back in.
All right, so really, there's no distance between the houses, and it's on the property line.
Is there currently a fence there?
no.
Then what does this say, proposed gate to replace existing chain link access?
There is a fence that part. That
Pardon?
we believe, there is a fence there. It's an access fence that remained from the previous creosote, the previous owner of the property that's being developed.
Okay.
That remained there, and it was our suggestion in working through this with Mr. Fierro was to ensure that there was not an access fence at the, I guess that would be the northern part, where the end of the sound wall and the end of this new fence, which is along Conrail, is closed permanently with no access gate. We discovered there's a current access gate on Angleside, which is where all the property owners are, which would provide a better, more appropriate access for maintenance by Black Creek, since it already existed there as a chain link.
Thank you.
And is it the agreement that you have with our professionals that you'll run the style and the details of the fence by them to get their approval?
Yes, that is correct.
All right.
Mr. Pateo, we have, Ms. Cosco and myself had a Zoom meeting with Mr. Fierro, and we discussed the height, the color, things such as that. We went over that with Mr. Taylor as well, the homeowners, and it appears that everyone is in agreement to what we're taking a look at and decided would be best.
Which is white vinyl.
Yeah, all right. Do we have any exhibits that we ought to identify in support of this?
We have the statement of ownership, consent, and support forms from the 4 properties abutting the fence.
Can we make that Exhibit A?
Yes.
All right, give that to the clerk. All right, and is the proposed fence sketch SK-1 also to be an exhibit?
Yes, we should make that Exhibit B.
All right, we'll make that Exhibit B. Give that, the clerk already has that, but if you have an extra copy, you can give it to her.
Yeah, I have extra copies.
All right. Mr. Kingsbury, while council's looking at that, any other exhibits that you think are appropriate to put in the record on this?
That is the one that yeah. Thank you.
Thank you, council. Any other exhibits that council thinks is appropriate?
Not from my perspective.
Okay.
Scott?
No, Chairman, thank you.
All right.
Yeah, I do have one question. With the warehouse and along the railroad, going south, I believe, at the bypass, there is a cemetery in there. Is this fence going to, are we near there? I can't totally picture that.
Can you speak in the microphone, please?
There is a there is a cemetery right near the railroad on the south side of the railroad going towards 38. I can't totally picture if this fence is going to be close to where that cemetery may or may not be.
This will not be near the cemetery. If you, everything depicted on the plan is just where the fence.
It will not be close to it at all.
Okay.
It's totally on the other side of the site.
Okay, well, I'm sorry, I just didn't picture that, it's okay.
It's totally opposite side of the site.
Okay.
Any other questions of the board before I open it up? Okay. Let me just open this to any public comment. Anyone in the audience have a comment? Come forward, stand at the podium, please. We'll hear you. Yeah, counsel, just stay there.
Let me swear you in. Do you swear or affirm the testimony you give will be the truth, nothing but truth, so help you God?
Yes.
Thank you.
All right, state your full name.
My name's Charles Bloom. I reside at 204 Ingleside. I actually have the property where the fence juts into the chain link area of it. The only problem that I have on the drawing is where my driveway is, where the proposed gate is. It actually goes across the road. I know I talked to Joe about it, and he said he was going to make provision to go up onto the grass and kind of go around that. I just want to make that kind of be fair and on record.
Okay, so you just wanted to make sure that the represented little change in the fence will in fact occur?
Yeah, he said everything was going to be up to Taylor and Kathy. You know, obviously when you go out there to look at it, I would have about 5 feet back out of my driveway before I would run into a fence.
Wait,
So not
I'm confused, I'm not aware of
After, I mean,
this. So it's where the
It's
existing
not on my,
fence
it's
is
not,
now?
this isn't on my property line. It's kind of goofy the way, I don't know, can I just show you, Kathy?
You're saying if you back out of your driveway where the fence is, you'll hit that fence and you just want
The new section of the fence, where with what I agreed to with the property line stuff, when it comes in, that's where my property line ends. There's a weird little triangle piece that goes from, so here's my property line right here. The street comes along here, right there, and then this little street that's in this corner.
Right, so you want to relocate an additional portion?
I would think that would need to get,
Let me just
Okay.
finish. Relocate some additional fence off of the common property line a little bit further back into the Black Creek site to allow you access.
I don't know whose property it is, because
It says
when I pull up the record from my survey, like I bought the house in
encroaching.
2019, there's, like I said, this little square right here, I don't know who actually owns it. It is grass. Mine goes straight across where the fence starts jutting in.
The orange line?
Yeah, the orange line, when it goes in, this section right here, like I said, it's kind of tough to see. This section right here is actually asphalt road. Now, if you look, I don't,
Well, nobody's gonna,
it's very difficult to explain.
yes, that's why I'm suggesting this. Take a moment
They're giving.
with a copy of the plan and draw on it the issue, the points that you're talking about.
So the road ends up going right to here, and then,
That's all going to be removed.
okay, so there's the road right here. I believe this is my driveway, my driveway would be right here. So I would have about this space to try to get out of my driveway. Where I believe this is road, this is not my property, so I can't sign off on, his intention to go right there. Like I said, I did talk to him, he said he had no problem jutting along the thing. I just wanted to be more aware of, or on record that this was going to be an occurrence. It's tough to try to explain without going to the site,
Let me
obviously.
see what you've drawn.
Sure. So right here is my property line,
They're gonna.
which is why he agreed that he was
Change lot
going to put
lines.
it where the existing chain link fence was.
Okay.
And then that comes that was gonna come across. I don't know what this section of property
Yeah.
is,
Joe's just going to give him the property.
because his,
Is that part of
All right, right here.
Ingleside Avenue?
yeah, this is Ingleside.
Yeah, but I mean, is that property up there part of that street?
Yeah, this is Brass right here.
Oh, okay.
What if they?
So I don't know, or this is Brass right here, this is his property line. So where it comes across, where the road ends here, there's grass right here, but like I said, my driveway is right here, so I would be just going right into the, I have about 5 feet of room before I would go into the vinyl fence.
So when you leave your driveway now, you actually have to drive onto that adjacent property.
I'm guessing I'm driving onto his property
Yeah.
every time I back out of my driveway, yes.
All right, let's take that sheet, the top sheet there, and we'll mark it as Exhibit C, give it to the clerk.
I have it already, sir.
Because I mean,
I have it already.
You have it. But the markings, do you have the markings?
Yeah,
No, I think you mean,
No, the
that
markings
was what he drew up.
that have just been
because I mean,
drawn.
it would be even tougher delivery drivers to even make it down the road to turn
All right,
around.
show it to council
Okay.
to make sure he understands what it is.
Okay, yeah, well, you can see on here, the way it's marked out, because he has all the properties marked off. Right here, I don't know who owns this triangle of property, but the road goes right here. My driveway is right here, so I would have that tiny amount of space to get out of my driveway.
So let me ask, how does the trash truck maneuver your road?
Backs all the way down.
How do delivery trucks maneuver your
They
road?
go straight down, they do, because it kind of bulbs out a little bit,
Right.
they do a turn into the driveway, back
Right.
up, and then
Right.
proceed out.
So I think in my conversations with Mr. Fierro is that, you know, he acknowledges this request and has provided that on the plan, that he's willing to basically grant them a portion of their property to use. And I made it clear, you know,
Sort of an informal easement.
correct, and my recommendation is that they formalize that easement, because who knows who the next owner is going to be, and,
and you're talking about where the orange line cuts
Yes.
onto the Black Creek
yeah.
property.
I mean,
So
right,
it almost sounds like what Mr. Bloom is requesting is that 10-foot, 12-foot offset into the Black Creek
Mhm.
be extended further down along.
Just along, yeah, just along where the road is, just outline.
Yeah, just,
Yep. Yeah, just a little outline where the existing
Let me
road is.
see it.
That way,
because that was, I don't.
like I said,
let me
it's-
see.
he was able to see exactly what I was talking about. Can you bring that, your highlighted one, that way I just kind of.
Yeah.
Well, that's our road.
Yeah.
Okay. Right. This makes it see. This is my property right here.
Mm-hmm,
The street goes right along here, but if you do, so there's this little triangle that I don't know who actually owns this little triangle, because the road stops right here.
that looks like Hainsport Township owns it, it's part of Ingleside Avenue.
Yeah, right, but it's grass.
That's
so
not that's not a triangle.
it would be-
That's proposed gate that's pointing.
No, right, this
Oh, I see.
area right
This
here.
little thing here.
Yeah, right, yep,
I see it.
because he put this to my, once it stops going on my line, that's when he put it exactly on his property line.
Okay, but
So I
what's,
have this little triangle piece that's, it's been grass, but then the road goes all the way to here. So this little triangle would be still asphalt, but his property goes across the asphalt road. So if you look right here, like where I would have to go out of my driveway, I'd have this just tiny little bit of area to try to get out of there.
which is what you have now?
No, there's the chain link fence, if you look right,
Yep, the existing chain link fence that's there now?
the chain link fence goes right here and it goes all along here and it doesn't touch, the gate for the chain link fence is actually right about here.
Okay,
So it's closer to, the chain link fence is actually closer to that sound wall, so it's just a slightly dotted on there. But like I said, I talked to Joe and he said that he would be able to jut it around there. I just wanted to make, like I said, I just wanted to make sure that it was on here, or that I can.
okay.
All right,
Yeah,
well,
'cause-
let me
I know it's
interrupt
on
you,
vacation.
because, you know, the here and there and all of that, they're never going to be able to figure out what that is in the record.
Right, yeah.
But the way to do it, it seems to me, is to have a site visit either when the fence is being put in or before the fence is put in, so that the fence can be aligned in the right way. But there's another issue, and that is, do you need to give this homeowner, if you would, an easement to, if it's needed, let me finish, if it's needed to drive over somebody else's property to get his car in and out? How do you feel about that, counsel?
Yes, we don't see any problem with extending the fence along the way that you insisted. We just we'll need to look at that, make sure it's feasible, and as far as the easement goes, we are in agreement.
All right, so mechanically, what's the best way to do this in terms of the planner or the town's engineer?
So I think what we would want to do is, if the board is agreeable to an additional fence generally along the property line, but moving in and out to accommodate gates and potentially driveway access, that final alignment can be worked out in the field and staked. I would probably have their contractor, as part of the field change process, stake the corners of that property, stake the corners of Angleside Avenue, so everybody is crystal clear when that happens, because whatever happens in Angleside Avenue, the township needs to know exactly what and where is happening.
Of course.
If there needs to be some additional pavement, and if Black Creek's willing to do that. But I think as long as the board is good sort of conceptually with this idea, the details can get worked out, but to protect the town and everybody moving forward, that should all be shown on a little sketch, and it needs to be surveyed so everybody in the field knows exactly what's where.
I would totally agree with Mr. Taylor on that one.
Counsel, you concur in that?
Yes, we can.
And sir, do you understand what we've been talking about?
You're talking about the road access.
Right, and making sure that your complaints, or not complaints, but your points are covered and
Like
resolved.
I said, I talked to Joe and Mark, Mark is the guy for Pentax, and he said that, they're willing to work with us with whatever little things that we can do.
All right. Now, counsel, on the easement issue, if it turns out that one would be appropriate, how will you address that with the homeowner? And I'm not saying it is or it isn't, I'm asking the question.
Yeah, that'll be subject to our client's approval, but we'll be able to work it out.
We understand, you'll use your best efforts in that regard.
Yes.
All right.
I would also ask the zoning officer for the town and for my professionals is that going forward, that we please make sure that we're all on the same page for whatever's going to go on out here, and that it even means if we all have to meet out there to make sure that we are protecting our residents as well as the town and the applicant, so that 2-3 years down the road, all of a sudden we realize is that none of us were on the same page. So I want to make sure that Black Creek understands that.
Yeah, I think that's a great idea.
All right, I'm going to ask if there's any public comment on this item. Seeing no hands raised, I assume there's none in the audience. Anybody online?
We don't have it online tonight.
No one online tonight.
Nope.
The computer's not working tonight.
No, it's okay. It's
So-
not required.
So that's all right.
It's optional.
All right, can I have a motion to approve the concept of the barrier fence as it is depicted in the exhibit to this hearing, subject to field approval by all parties involved?
And an easement.
Well, the easement would be up to them.
Yeah, is the easement part of the resolution? I would think,
If this gentleman drives across their property every day, it's going to need the easement.
And a resolution, would that be between them?
I would recommend that unequivocally, if the fence is going to move and there are configurations, that there should be easements. And the only reason I say that is, we've had this happen with other warehouses. This could be sold in 3 months, and that new owner may not be as agreeable with these owners as Black Creek is currently. So if we're going to allow these fences to move in and plants to be planted and modified and potentially somebody drive over, if there is going to be private use on the Black Creek site, I think for everybody's protection, an easement should be required.
So then an additional subject to the planner's approval would be the requirement that an easement be filed with respect to the end of the fence near the property in question.
Yeah, for any of the modifications as necessary. And that way Marty, Bob and I can look at that. Those guys can review the easement language. But there's that final sketch that gets developed can actually also work to point out some of the easement stuff, however it gets filed. It's up to those guys. That way everybody's clear, even if Black Creek moves on.
Right. Counsel, I'm going to ask you if for your comment on the form of this motion, only because of the easement addition that was put on, just by suggestion of counsel.
Yeah.
Do you have any alternate proposal on a motion?
I think we're okay with the proposal. Once we look at the fence again and make the necessary revisions, if an easement is needed, we will certainly give it our best efforts.
All right. So I'll make a motion just to clarify it, that the board approves the concept of the fence as proposed in the exhibit, subject to approval by our planner and subject to the property owner agreeing to and arranging appropriate easements to be filed to deal with the concerns of the adjacent homeowner. Is that clear enough to everybody? All right, so that's the motive, the motion. Is that clear to the board?
It's clear.
I'll second it.
Thank you. Roll call?
Mr. McKay?
Yes.
Mrs. Kelly?
Yes.
Mrs. Torti?
Yes.
Mrs. Baggio?
Yes.
Ms. Cosko?
Yes.
Mr. Bradley?
Yes.
Mr. Novarita?
Yes.
Mr. Holden?
Yes.
Motion passes.
All right, motion passes. Thank you, counsel. Did a great job. I understand this is your first hearing?
Yes, that's correct.
Welcome.
Good job.
Welcome to the fray.
Thank you very much.
I'll tell your grandmother you did a great job.
Just what every young man wants to
Absolutely.
Well, you can tell his,
in the face, Ms. Baggio.
tell his grandmother he won his first hearing, all right?
A great job.
I just want to know.
And there's no used cars on this site, right?
Thanks, Scott.
So, all right.
Yeah.
All right, can we look at the rest of the agenda? We've got minutes from, we have minutes from 2 meetings. No, we have a regular meeting, yes, the regular meeting and the reorganization meeting. So we have minutes from 2 meetings.
Yes.
You could
Can I
actually
combine?
do that in one vote,
I-
why, because everybody was the
Yeah, can we
same.
do it?
I think everybody is the same, so
Yeah.
can I have a motion to approve the minutes from the January 3rd regular meeting and the reorganization meeting?
I make the motion.
I'll second.
All right, roll call?
Mr. Holden?
Yes.
Mrs. Baggio?
Yes.
Mrs. Torti?
Yes.
Mrs. Kelly?
Yes.
Ms. Cosko?
Yes.
Mr. Bradley?
Yes.
Mr. Novarita?
Yes.
And Mr. McKay?
Yes. All right, we've got a bunch of resolutions. Resolution 2024-12, the Hainsport Family Apartments LLC. Can I have a motion on that?
So moved.
Second.
I second.
Okay, we got,
You can't
Your
have
third.
executive because you didn't vote on it.
yeah,
Did you,
we got Gus, we have a second here.
Mr. Bradley, you weren't here?
I'll second.
Bradley wasn't?
In January?
I was here.
Yeah, you were here.
He wasn't here for
All right.
All right. Roll call. Give a
I
second.
wasn't here.
Mrs. Shorty?
Yes.
Mrs. Baggio?
Yes.
Mrs. Kelly?
Yes,
Ms. Costco?
Yes.
And Mr. McKay?
Yes. Resolution 2024-13, John D. Pietropola, side yard setback variance.
I'll make that motion.
second,
Roll call.
Second, did you second that?
Ms. Kelly.
Tish.
Ms. Kelly.
She was too loud.
they're never happy.
You got too close, I thought you beat that loud. Ms. Costco?
Yes.
Mrs. Kelly?
Yes,
Mrs. Shorty?
Yes.
Mrs. Baggio?
Yes.
And Mr. McKay?
Yes. Next, we have Resolution 2024-14, Caravajo Carpentry, Inc.
I'll make a motion to approve Resolution 2024-14.
I'll second.
Roll call.
Mrs. Baggio?
Yes.
Mrs. Shorty?
Yes.
Mrs. Kelly?
yes,
Ms. Costco?
Yes.
And Mr. McKay?
Yes. Finally, we have Resolution 2024-15, the BTC Urban Renewal Preliminary Final Site Plan Subdivision Approval.
I'll make that motion. I'll second.
Roll call.
Mrs. Shorty?
Yes.
Ms. Costco?
Yes.
Mrs. Kelly?
yes,
Mrs. Baggio?
Yes.
And Mr. McKay?
Yes. Next, we have a number of items of correspondence. What's the board's preference?
I make a motion that we approve and accept the and filed correspondence.
May I have a second?
I'll second. I'll second.
I think we can do that by consent. All in favor?
Aye.
Any opposed? Ayes have it. Item 10 is professional comments. Any? Board comments? Any?
I have a comment.
Yes.
Okay, thank you. So I just wanted to speak on behalf of my experience with Black Creek through this process. You know, Mr. Fierro reached out to us and, you know, he stated he had met with the residents. They had his number from the beginning of this process and went out to the site and was affected by the development and the implications on the property owners. And I just want to commend their desire, willingness to do what they can to work with and help the residents. You know, the 6-foot fence is to give them relief from the site conditions. Obviously, construction is going to be going on for quite some time. It wasn't just this issue. We also had a concern from a resident that lives in that community a little bit more inside of the neighborhood with some stormwater issues. Black Creek addressed it immediately, mitigated the situation, addressed the stormwater issue that quite frankly had been there for decades with the creosote plant and the way the swale is along the railroad tracks. It's evident that issue's been mitigated with today's and yesterday's and the day before's rain. But, you know, they are addressing the residents who are directly affected by this development swiftly, quickly. Their communication is amazing. They're, you know, addressing any concerns that we've had up to this point, meeting and communicating with us on a regular basis. The torch has been handed over to Kathy in her office, I'm sure, and it sounds to me like she can say the same thing. The relationship has been great. I just want to say, for the benefit of Black Creek and some of the background noise that happens with these developments, that, you know, they are top-notch developer. It has been a great experience up to this point. Obviously, we've been working with them for a couple years now through the redevelopment. So just want to say that from an administration standpoint, from the township standpoint, and I take a danger of speaking on behalf of the residents, that, they are doing a good job and making sure they're being good neighbors and good developers in Hainesport. And we just appreciate that.
Thank you, Ms. Costa. It's very gracious of you to go out of your way to make these comments, and it's nice to know that we have a responsible developer in the company.
Just to let you know, we did receive their construction permits for their 2 buildings, so we are in the process of reviewing them and looking them over, and our hopes to have them out probably within the next couple of weeks. We did receive the approved site plan. Thank you, Mr. McKay, for coming in and signing them for Mr. Krollpfeifer while he is out, so that helped us out a lot by you coming in. So again, as a team effort, I think we always work real well.
Well, that's the way we want to do it in this town, and we've tried to do it, and I think we do it.
I agree.
Public comments, any? Few members of the public out there, no one has any comment? Now's your time. Okay, no public comments?
I'd like to make a comment, please.
Sure.
I'd like to recognize Ms. Kathy, because even though the first issue that we had to deal with, I would like to recognize your due diligence, that you went out there and you saw it right away, what was happening on that property, and you came back and you presented it all to us. And you're doing your job. You're doing a great job.
Thank you.
So I just wanted to recognize you for that.
Well, I'd like to thank the board too as well. Me and Mr. Kingsbury were kind of chuckling earlier on, is that in my 20-plus year career, this is, I think, was the second or third appeal that I had. There were things as well is that I could not bring to light because they were conversations, nor would I put that in jeopardy of anybody. So again, I look at appeals as a fair way. That's what it's about. They have the right to. And the fact is that you folks are my bosses. So the decisions that you make, I just walk away at the end of the day and go, okay, it's all good. So I do appreciate you doing your due diligence and considering both the applicant and myself. And I think that this is really what it's about. It's supposed to be objective, not one side or the other. So I appreciate when you are here and your time and you look at things diligently and just not make decisions. So I thank you for your time.
Thank you, Kathy. Thank you.
All right, with that, I have a motion to adjourn.
So moved.
Second? Second. All in favor? Aye. Aye. The ayes have it.
Yeah.
That was,
Thanks, Gus. Couple of good questions there. Yeah, absolutely you should. I'm glad you're here. You are the man.
Yes, you did a great job. Very thorough, everything on the record.
And is that you're really your grandson? Or did I misunderstand? Somebody's grandson. Oh, you just know the name. Yeah. Because he is so young.
I got news for you. He is young.
I know, I do, I'm nervous. Part of my life.
It's a very good firm. Very good
I
firm.
thought you were going to be gone, I didn't see you out there.
All right, everybody, have a great drive.
You too. Say Chris for me. That did my best.
See your daughter?
Yes, I will see her.
Okay, see you, Tom.
All right, Gus. Take care, bro. See you, man.
Oh.
We'll see. The family reunion is.
Very